Good afternoon, everyone, and thank you for joining this Use Laboris webinar. My name is Alessia Perez, and I will be facilitating the session for you today. Today's webinar, the second of the restructuring series that we started last week, will talk about what can possibly go wrong, employment law risks in restructuring, and the perspective of the countries as Singapore, Malaysia, and India, and will be given by a set of panelists from different member firms of Use Laboris. Today, indeed, we have lawyers from Singapore, India, and Malaysia. Before we kick off the session, I would like to clarify a couple of points on the housekeeping side. If you have any questions throughout the session, you can use the Q&A tab to send your questions to us, and panelists will answer as many as they can. You can, of course, also reach out to the panelists by email after this webinar. Regarding the slides, they will be available on our website along with the recording after the webinar. I will now turn over to Sue from Screen, our Malaysian firm, to begin the session. Go ahead, Sue, you're welcome to start.
Hi, everyone. Thank you for taking the time to join us for today's discussion on what could possibly go wrong, employment law risks for restructuring, Singapore, Malaysia, and India perspectives. So one of the things that I've come to realize about restructuring or retrenchment in Malaysia is that it is very often a business or commercial decision made in the boardroom, but which is judged in the courtroom. Is this also the case with Singapore and India? For the roadmap of today's session, leveraging of our fantastic panel of experts, Gagan Verma from Kochar & Co, India, and TP Ang from Raja & Tan, Singapore, we will first look at some case studies in each jurisdiction and learn about the legal risks and exposure for businesses in those jurisdictions. We will then move on to the best practices and the requirements for conducting retrenchments in the 3 jurisdictions. We will also talk about common pitfalls that we have observed. And if we have enough time, we will then consider whether senior employees or management level employees should be dealt with differently. We can also talk about alternatives to retrenchments, and we can briefly discuss trade union involvement before concluding and ending with key takeaways from Singapore, India, and Malaysia. In Malaysia, we have certain news portals like Free Malaysia Today, for example, which regularly publish headlines like ex-vice president of GLC, Government Link Company, awarded 1.3 million ringgit for wrongful dismissal, or other headlines like this. Very sensational headlines, which always capture the interest of all readers in Malaysia. And very often, we will then get questions from the public and our clients, companies and businesses as to what it takes for a retrenchment to be considered just cause and excuse in Malaysia. Now I will just very briefly explain the AirAsia X case, which is a very recent and interesting decision in Malaysia. So all 3 cases here are all 2025 decisions in Malaysia. And the AirAsia X1 is a very interesting retrenchment decision that has come out from the COVID-19 pandemic. So following from the COVID-19 pandemic and the movement control order in Malaysia, AirAsia X had terminated a pilot's services, and the selection process that it had used was its own best fit policy, as opposed to the standard last in, first out recommended policy for selection. In respect of the AirAsia Best Fit policy, the company, in respect of AirAsia's Best Fit policy, the company considered the pilot's performance for the year 2019 and held based on its own point-based system that the pilot was not the best fit and hence chose that specific pilot for retrenchment. The industrial court found that his dismissal was without just cause or excuse and held that the selection process was not done in a fair and reasonable manner. The court found that while AirAsia was not prohibited from using their own selection process in retrenchment, the selection should not be carried out in an arbitrary manner. The industrial court also found that it had the right to scrutinize any alternative selection methods for retrenchment. And in this case, it scrutinized AirAsia's ex-best fit policy and found that it was unfair. The court also found that AirAsia was unable to show how the claimant's position had become redundant because in this situation, it had only occurred 3 months following from the implementation of the movement control order in Malaysia. And the court also found that all other pilots in Malaysia were facing the very same situation. And because of these factors, the court held that the company was not able to justify the redundancy of the pilot in this particular case. In terms of the remedy, the court awarded compensation in lieu of reinstatement to the pilot. And this was at the rate of 1 month's salary for each year of service. And as in this case, the pilot had completed 11 years of service, it was 11 months of salary. And in addition to that, the court also awarded 24 months back wages to the pilot. From that back wages, the court then made a deduction of 15% for post-dismissal earnings received by the pilot following from his dismissal. So now, moving on to the issue of remedies in retrenchments in Malaysia, when a permanent employee is retrenched in Malaysia, the industrial court has the power to award, as I mentioned in the AirAsia X case, up to 24 months of back wages to the employee. Essentially, these 24 months wages, back wages, but is for the period between the dismissal of the employee up until the date the decision is rendered in Malaysia. So it is to buffer for that period, and it is kept at 24 months, regardless of the total period of time that the court takes in reality. So it is kept at 24 months, and the court can then either award reinstatement to the former position or compensation in lieu of that reinstatement. If it's compensation in lieu of reinstatement, it will be 1 month for each year of service, as was awarded in the case of AirAsia X. And as mentioned also in the case of AirAsia X, the court can then also make a deduction, a percentage for post-dismissal income. Typically, this would be between 10 to 40% of the back wages, but there is no mathematical basis for this. Also, if any payments have been made, for example, if retrenchment benefits has already been paid to the employee, the court will also deduct that amount from the final award. So this would be the remedy for permanent employees, and it is indeed a very huge liability for permanent employees. For fixed-term employees, the liability is slightly smaller. It will be the balance unexpired period. But as mentioned, there is a possibility of reinstatement, although not particularly common, because typically in such situations, the relationship between parties would have broken down. So reinstatement is not a very popular remedy, but there is a possibility of reinstatement being awarded to the employee. For example, the second title that we have here, ex-senior executive wins final appeal. In this case, because of that executive's age and seniority in the company, she was 58 years old at the time of the federal court decision. The federal court awarded her with reinstatement in that particular case. And this generally is very frightening for a lot of businesses to have the employee reinstated to their business, especially if the role is truly a surplus and no longer in existence. So the labor laws in Malaysia, I think, as you can see, are generally very protective over employees, and retrenchments can lead to litigation. Now, moving on to India and Singapore, is it common for restructuring and retrenchment exercises in your jurisdiction to lead to litigation? And what are the legal risks and exposure that employers face in such cases? Gagan, maybe you would like to start with India.
Yes. Thank you, Suli. This is a very interesting insight on Malaysia. In India, thankfully, we do not have dedicated news portal publishing headlines on compensation awards in the way that Malaysia does. However, media attention is very much attracted, and it becomes front page news when large companies they attempt to restructure and consequently retrench employees. Regarding your question, let's face the reality, which is that in India it is difficult to obtain orders from industrial tribunals, and sometimes they become very time-consuming, costly, and uncertain for an employee. So, and mostly, as a matter of practice, upon filing a complaint, the labor authorities they try to mediate and settle the matter between the employer and the employee, and refer the dispute to the industrial tribunal only if the mediation fails. So, regarding your question on how common it is it for employees to actually pursue litigation? Candidly, the chances of the dispute converting into litigation and ending up in a courtroom are low. Broadly speaking, Indian law requires the retrenchment to be based on reasonable and justifiable grounds, and the employer must follow the prescribed procedure under the Industrial Relations Code, which is now being effective and replaced the Industrial Disputes Act, and pay the retrenchment compensation to eligible employees. So, on the legal risks and exposures, I would like to highlight the same through some recent cases to give you a flavor of where India is moving towards. This is a 2025 case of Salunke, where the employer retrenched 5 permanent employees, each with over 20 years of service, on the ground of not having enough work. Now, the Bombay High Court did not accept this to be a justifiable ground and awarded a reinstatement with back wages. Surely, in India, we do not have a cap of 24 months. It is completely based on merits, what the court would decide. Now, the court observed in this matter that the procedural compliances alone, without genuine and demonstrable economic justification, is not sufficient, and that permitting such terminations would revive the discredited hire and fire policy. In India, we do not follow that. So the extent of financial exposure for the company is evident from here. So this is one of the very interesting cases in India we have recently seen. I would also like to highlight, one of the cases of TCS, which is one of the major employers in India in the IT sector. This will demonstrate on how restructuring risks can escalate rapidly. Now, the TCS reduced its workforce. They have been doing it consistently by approximately 5.3% in 2025, which affected 12,000 mid to senior level professionals, and this became headline news in newspapers. Now, in this matter, the employees alleges that they were placed under pressure through performance improvement plans and reduced bench periods, effectively forcing them to resign without adequate compensation or remedies. What followed was an industrial dispute filed by Karnataka IT Employees Union, accusing TCS of conducting an illegal retrenchment program. The Center for Indian Trade Unions, on one of the India's largest trade union federations, they backed this action and called for nationwide demonstrations at all TCS establishments. So the Karnataka state government has since called a reconciliation meeting. So all of this, at a company, at the employer reporting, revenue growth and 24.3% of origin of profit margin. Uh, these these kind of cases demonstrate that the employer, the practices which have been followed by the employer in the past for retrenchment, with thinking about that these are low risk action items, they have to be remain aware of it and be careful while taking actions, because the risk is very huge. The takeaway from these the cases is clear, that even where a company is not in financial distress, the manner in which the restructuring or retrenchment is conducted can trigger union escalation, regulatory intervention, which is very new, and significant reputational damage. Uh, we generally recommend our clients to take employees into confidence and follow a consensual rather than a unilateral process. Uh, thank you, Celine, from my side.
Thank you, Gagan. I think that is very interesting. What about you, TP? What can possibly go wrong in Singapore?
Right. Thanks, Sue and Gagan, for sharing earlier. Listening to what the two of you had to say, I think the first comment I have to say is certainly not exciting in Singapore as it is in Malaysia and India. No, not you don't really see significant retrenchment related or restructuring related litigation, nor do you have the threat of industrial action or strikes by your employees. But what I wanted to just share is just give you a brief flavor of maybe perhaps just three cases that you can see to talk about what employers may find themselves facing when it doesn't comply with the requirements or its obligations when conducting these restructurings. And that's something that we'll talk about later. In Singapore, the problems and difficulties really manifest itself in two related or integrated manners. One is approachment or scrutiny by the regulators and the unions. And then at the same time, intertwined with that is media scrutiny as well. And that in and of itself creates a very powerful effect where the regulator is then, in a sense, almost pressured to take action and to administer some form of administrative penalties or regulatory action against errant employers. So you have in this situation the DFS one. This was some time ago, a few years ago, prior to COVID. And what they had done was they had laid off about 50 staff with immediate effect and no prior notice. So there was actually a requirement, and I'll talk about that later in terms of giving early notice to your employees. And they were so in this case, they didn't give them any notice whatsoever. And the employees were only offered retrenchment benefits of 1 week's pay per year of service, which is also below the customary norm. And that's something I'll talk about as well. So this gathered extensive media coverage, and it drew public criticism from the Ministry of Manpower, and who then commented actually that the retailer could have handled better the retrenchment exercise. So in this case, what happened was that the Tripartite Alliance for Fair Employment Practices, and in short, we call it TAFEP, they stepped in to engage with DFS and to moderate the retrenchment payments sort of being given. So that came at a cost in terms of engagement with the authorities, consulting the lawyers, spending time and effort to conduct the retrenchment exercise properly, sort of to redo it again. And it was something they could have avoided had they done so properly at the beginning. And as well as, of course, receiving all of this adverse media publicity. For those of you based in Singapore, you may be even more familiar with, I think, a more recent case, Lazada, just 2 years ago. They laid off an undisclosed number of employees. And what was significant was that they actually did the retrenchment immediately after the New Year, and without any advance New Year festivities and without any advance notice. So which generated very significant public backlash. Employees were posting their retrenchment notices and what's happening to them on social media. And then, the news media, traditional media picked up on it, and they started commenting as well. And the overall criticism was that the package offered was unsatisfactory. that they failed to again notify in advance, and that they failed to sort of display and respect cultural sensitivities in relation to when the retrenchment exercise was being conducted. So again, in this case, the union had to step in along with the Ministry of Manpower to facilitate discussions. There were tripartite negotiations and mediations taking place. And after some of these negotiations, the employees received enhanced retrenchment benefits, as well as other sort of employment facilitation measures. So on the contrary, comparing to these two sort of negative examples, you have what I consider to be one of the better examples, Carousel, where they cut about 7% of their total employees. And in this case, it was very simple. It was this one media report about the exercise, and thereafter, no further commentary, no further follow-up newspaper reports. And that's what I consider to be that ideal kind of situation where there isn't any negative publicity, and social media commentary is also very positive about the way in which you handled it.
Sometimes TP on that, no publicity is good publicity.
Of course, excellent. Yeah, definitely. So in this case, if you see some of the companies, the media picks up on it. There's actually a statement by the union, statement by the company, and even a statement by the Ministry of Manpower. And you know that all of this has been coordinated in advance. And so, it's a one-time report and that's it, and no further action. So that's what I consider to be a good example of what happens when employers do right and plan well. So in this case, Carousel had already proactively worked with the union in advance to ensure that the union members and employees were offered fair compensation packages in line with the advisory norms. In this case, I think all of them received a minimum support package, about 1 month's salary per year of service, with a minimum of 3 months compensation for all employees. And everyone was allowed to encash their paid leave, paid time off balances, and flexible benefits. So even for foreign employees who were here on work passes, they allowed them to serve out their full notice period, and then preserving their right to remain in Singapore for as long as possible. So they even issued the union, in this case, had already prepared a statement that was sort of cleared beforehand with the Carousel for publication in the media. So that's how an example of what can go well if employees plan well.
Thank you very much, DP. I think that's very interesting. So having heard the risks that businesses face in these jurisdictions, and having heard that, Carousel seems to be somewhat of the gold standard as to how we should conduct retrenchments in Singapore. TP, can you tell us a little bit more about the best practices and requirements for conducting a retrenchment in Singapore?
Yes. So the way I look at it, I would like to classify it into 3 buckets, right? So if you're an employer and you're conducting a restructuring or retrenchment in Singapore, the first question you have to ask yourself is, what are the sources of obligations or requirements that I need to take heed of? I think the first you need to look at is your own company documents, your contractual documents. What do your employment contracts say? What do your policies say? Do you have a policy or a handbook that deals with terminations or retrenchments? So you comply with the notice provisions in the employment contracts. You comply with various notice provisions or payment requirements that are stipulated in any of the applicable policies or handbooks that you have relating to retrenchments or terminations, at least from your company's perspective. So you adhere to these internal requirements. At the same time, when you are doing so, when you have a look at these contractual documents and you look at what the individual employment contracts say, you will already know what are the necessary wage payments, allowances, bonuses, and then outstanding payments that you need to sort of prepare for in advance, so that you know that on the effective date of the termination, on the final date of termination, all of this is in place. So that's why I consider the first bucket, the company's internal documents and internal contractual documents, as well as its policies. The second is this tripartite advisory on retrenchment, on managing excess power and responsible retrenchment in Singapore. So this is actually an advisory created by the Singapore National Employers Federation, the Ministry of Manpower, and the National Trade Unions Congress. So this is an advisory. So I tell our friends, our clients, that it's not, strictly speaking, it's not law. It does not create legal obligations per se. But it's very unique in Singapore in the sense that the Ministry of Manpower generally expects employers to comply with the advisory as though it has the force of law, unless there are very good reasons not to do so. And if employers don't comply with the advisory, they may then find themselves subject to regulatory scrutiny, as we have I've talked about in those examples and in the case studies, and being subject to regulatory penalties or administrative action, the most powerful of which is the debarment or curtailment of work pass privileges in Singapore. So if you have a multinational corporation that hires about 20 or 30% of its workforce on work passes, the inability to renew these work passes or hire new employees on these work passes will create a very significant operational and administrative strain on the company's operations. So complying with the advisory is a very important aspect of it. And part of the advisory has what we call pre-retrenchment obligations, retrenchment obligations itself, and post-retrenchment obligations. In the sense that pre-retrenchment in terms of how you select, whether you consider alternatives, how you selected the employees for retrenchment, in terms of the retrenchment process itself, giving early notification to your employees, and engaging in consulting with the unions where it's applicable. And then finally, in terms of making the payments, making sure that the retrenchment payments and benefits that you provide are in line with the advisory norms, along with the employment facilitation measures that are all set out in the advisory. And the very last bucket is what I'll consider the regulatory sort of requirements in a sense, where there is a mandatory notification to the Ministry of Manpower once you complete the retrenchment exercise. The second thing is in relation to your foreign employees, you cancel your work passes, the employment passes, and the work permits for affected foreign employees. And then you apply for the necessary short-term visit passes for them. And you got to take note, of course, of your compliance with the exit timelines as well as various tax and immigration requirements. So if employers generally take note of these three buckets, I think you more or less have the ABCs to conduct responsible retrenchment in Singapore, and you probably not need me to advise on the process. See you.
So we have the ABCs in Singapore, but it's not so straightforward in India, is it, Gagan? What are the requirements that businesses need to be aware of when retrenching employees in India?
Thank you, Sioli. You're right, it's not that straightforward at all in India. I'll quickly catch up with this. The very first step is to determine whether the employee falls within the definition of worker under the Industrial Relations Code 2020. If the employee is a worker, then the full statutory retrenchment process must be followed. If the employee is in a managerial or administrative role, the termination is governed primarily by the Employment Contract and the applicable State Shops and Establishments Act. So we have that distinction. So for the worker category, which is most important, the Industrial Relations Code prescribes a mandatory process. The employer must provide 1 month's written notice stating the reasons for retrenchment or pay wages in lieu of the notice period. So immediate termination is also possible, but the reasonable cause justifying the termination is very important to be provided. The employer must pay retrenchment compensation at 15 days average wage for every completed years of continuous service. And the employer must also follow the last in, first out principle, but that is not a hard and fast rule. This can be taken back seat if the board comes record the reasons for not complying with this. So, but for larger companies in India, like manufacturing units, where the establishments have more than 300 workers in factories, mines, and plantation activities, the employer must obtain prior permission from the appropriate government before effecting any retrenchment. So this is how much it is regulated. I would want to give you a snapshot on some the practices which are specifically being followed by the IT and service sectors, where the employers generally prefer not to go down into the strict statutory route. What we see very more commonly is that employers initiate discussions with the employee for a mutual settlement. So the employer offers a discretionary ex gratia payment over and above the statutory retrenchment compensation in return for a clean and amicable exit, which also includes signing a mutual separation and general release agreement, which typically covers a mutual release and claims, confidentiality, non-disparagement, and a waiver of the right to raise an industrial dispute. So this route significantly reduces litigation risk and provides certainty to both the parties. One important aspect which is now very important and a practical point which often catches multinational companies off guard is that the requirement to pay all the terminal dues, whether it's retrenchment, compensation, notice pay, leave encashment, gratuity, they must be disbursed within 2 working days from the last working day, as per the Code of Wages of 2020. So this means that the payroll cycle must be adjusted well in advance to ensure compliance with the requirement. And finally, after the termination is effected, the employer must file the prescribed intimation with the labor authorities in the relevant state within 3 working days from the date you have made full and final settlement with the employee. So in essence, the process is classify the employee which is difficult, slightly difficult, justify the cause. You need to have your backup papers ready, follow the statutory procedure or negotiate a mutual settlement, pay promptly, and intimate the authorities. So these are 5-6 buckets where one has to follow this. Thank you, Celine.
Thank you, Gagan. I think in terms of similarities, we are a little bit more similar to India. We also have about 5 to 6 buckets, which I'll quickly go through now. So at the outset in Malaysia, it's not so easy to fire an employee. There is no employment at will in Malaysia. Employees are quite protected in that all terminations have to be with just cause or excuse. And this includes cases, even if you have that termination, a perfect termination clause in your contract of employment, notwithstanding that clause, if the company wishes to terminate the employee, it has to show just cause or excuse. And yes, retrenchment can constitute just cause or excuse, but we have these 5 buckets that we now have to look at. And the first bucket would be that you are able to show a genuine redundancy situation. So in showing this genuine redundancy situation, yes, the company has a right to reorganize, provided that company acts in good faith and there is no victimization of the employee. And to satisfy this requirement, it is very important that the reasons for the redundancy and the decision for the retrenchment are properly documented. So this is critical to retrenchments in Malaysia. You must document your reasons for redundancy and the decision-making process for the retrenchment, because if a dispute arises, this is what the court will scrutinize. The second bucket would be the selection of employees. So this is what we discussed earlier in the Air Asia case, what went wrong in the Air Asia case. Essentially, the general principle in Malaysia would be the last in, first out principle. And if the company or the business chooses to depart from that last in, first out principle, it has to have strong justification for the departure. So in the Air Asia X case, the court found that following the company's own best fit policy and departing from the LIFO principle in that case, Air Asia X was unable to justify that. So another very critical requirement in Malaysia is actually for the company to be able to justify a departure if it chooses not to follow the last in, first out principle in retrenching the employee. The third bucket for retrenching an employee in Malaysia would be compliance with the Code of Industrial Harmony, the Code of Conduct for Industrial Harmony. So the Code of Conduct for Industrial Harmony in Malaysia is essentially a document which is like a guide which the courts refer to. But again, this does not have, it is not legally binding. So the Code of Conduct for industrial harmony in Malaysia, it is not legally binding, but the courts regularly refer to it as guidance of the recommended approach and best practice when retrenching an employee. And in this code, essentially, it gives recommendations to businesses, such as, the recommendation to consult with employees, the recommendation to give reasonable advance early notice to employees before retrenching the employee, the recommendation to consider alternatives to retrenchment prior to retrenching the employees. For example, transferring to other departments, retraining the employees, voluntary separation schemes, for example. So that is the third bucket in Malaysia. Now, the fourth bucket would be giving notice of termination to the relevant employees. And in Malaysia, this will be in accordance to the employee's contract of employment, terms of employment, but subject to the statutory minimum in the Employment Act. So whichever is more favorable, you have to follow the provision which is more favorable in respect of the termination notice. And the termination notice in the Employment Act, it is between 4 to 8 weeks notice. This is the statutory minimum. It is between 4 to 8 weeks notice depending on the years of service of the employees. And of course, as I mentioned earlier, if the contract of employment provides for a more favorable term, the more favorable term applies. Then moving on to the fifth bucket would be the retrenchment benefits bucket. In respect of retrenchment benefits, again, if it's provided for in the employee's terms of employment, then it applies. If in the absence of any provision in the employee's terms of employment, then the court will consider whether the employee falls within a category known as covered employees, or they are non-covered employees. For covered employees, essentially these are employees who earn 4,000 monthly salary of 4,000 ringgit and below, or regardless of the quantum of monthly salary, they perform manual work, supervised manual work, they are drivers, and typically blue-collared employees. If they fall within this category, which we regularly refer to as covered employees, they will then be subject to that minimum retrenchment benefits provided for under the Employment Act. And the minimum retrenchment benefits provided for under the Employment Act will be between 10 to 20 days wages per year of service, again, depending on the years of service. So it will be between 10 to 20 days of wages per year of service. But if you fall outside this scope, i.e. you are a non-covered employee, it is up to the employer whether the employer is going to pay retrenchment benefits to the employee or not, in the absence of an express clause requiring it. But the general expectation in Malaysia in a retrenchment situation is that most employees do expect to receive 1 month's salary for each year of service. So that is the general expectation, but of course it can vary from industry to industry and depending on the precedent already set in the company. The final bucket, so there's an additional bucket in Malaysia. I think this is bucket number 6. It would be the notification to the authorities. This is the filing of a form known as the PK form in Malaysia. This is essentially just a notification to the Labour Department in Malaysia that a retrenchment is taking place. It is, I think, for statistical purposes, and it is not for us to seek approval from the authorities. So it's not to seek approval, it is more of a notification process. I think now moving on very quickly to the common pitfalls that we see. What are the common mistakes that employers make when conducting a restructuring or retrenchment in India, Gagan?
Thank you, Suli. The pitfalls in India are quite similar, in every jurisdiction. But I would like to, since we are less in time, I would want to highlight one very important aspect is regarding the employer's neglect of the human dimension of the process entirely. A retrenchment exercise, even when conducted in strict compliance of law, can profoundly and adversely impact the motivation, enthusiasm, the efficiency, and the overall productivity of the employees who remain. So the employers who treat retrenchment purely as a legal compliance exercise without addressing the communication and the emotional impact often find the real cost is not the severance payment, but the loss of trust and productivity across the remaining workforce. This is something which I would like to highlight because in India, we are a federation of so many states and with different multilateral cultures and languages. So we need to take care, the employer need to take care in which city or state the employer is trying to retrench and accordingly, take the first step. The other aspect is on the employer's overlooked interplay between the central and the state legislations, where India has a concurrent list of framework where both the center and the state can legislation on labor matters. So the Shops and Establishments Act on various states, may impose additional requirements for termination, which run parallel to the Industrial Relations Code. So the failure to comply with both the sets of requirements can expose the employer to maybe to pay extra or to become non-compliant. This is the two things which I would like to highlight. Thank you, Sylvie.
Yeah, I think before we conclude in Malaysia, I think 3 key takeaways for businesses would be number 1, to follow the proper process when retrenching employees. Number 2 would be to document your decision-making process. Number 3 would be to strategize the optics and the communication as well of the bad news to the employee as early as possible. TP and Gagan, maybe TP first. What are the key takeaways in Singapore?
Yeah, thanks, Shuli. And actually, I just want to amplify what Gagan was saying earlier in terms of the human aspect to it. Something, as employers, they probably, don't emphasize as much as possible. The tripartite advisory that I spoke about earlier, they already baked it in the sense that they tell you it's a requirement to communicate as sensitively as possible the information about the notification of the retrenchment and to also put in place measures to help your employees. So on that aspect, I think one key thing to take note is that employers should be aware and they need to plan ahead and in advance in terms of how the retrenchment is going to be conducted and especially why it's being conducted, the context of it. So if it's, for example, your manufacturing client and your manufacturing entity and you're closing down your entire plant and you're transferring your business out from Singapore, maybe to say Batam, low-cost jurisdictions in Batam or Bintan. And the process is going to take you maybe 3 years to wind down the entire plant and factory. And then you need to plan, other than the fact that you're retrenching the employees, you'll need their assistance to help you conduct the transition. And so you'll need to plan in advance retention bonuses. How are you going to retain the employees? How are you going to keep them loyal? What are you going to do in terms of discipline and morale in relation to the fact that they're losing their employment? All of these things need to be planned in advance. So we help structure some kind of incentive agreements for them to stay. We need to emphasize the disciplinary aspect in terms of what they will lose if they were to be subject to any kind of disciplinary action. And and what are the key objectives and when they'll be notified in terms of because the retrenchment is going to be conducted in phases, which tranche of employees you're going to fall under. All of that needs to be planned in advance. And you may even have other types of retrenchment or restructurings where it's a simple maybe closure of one department or you're letting go just 7 employees. So employers shouldn't take a one-size-fits-all approach. They should not assume that the templates that they have prepared in advance, I've conducted this exercise before, I know what to do, applies to all situations. I think that's something that they should be very alive to these kinds of considerations. Silly.
Yeah, I think actually the underrated requirement, actually not a legal requirement per se as well, but a strategic one is actually optics and communication. Gagan, what are the key takeaways from India?
Thank you, Cindy. I would like to summarize this in 5 quick takeaways for India. First, process is paramount. Industrial Relations Code prescribes mandatory conditions for retrenchment. So non-compliance renders it void. So, and as the Salon case showed, what I discussed earlier, even full compliance will not save the retrenchment that lacks genuine economic justification. So that is something which the employer must take care of. Second, know your threshold. If you're a large setup in India and you have 300 or more workers in a factory, mine, or a plantation sector, this would mean prior government permission. Retrenching without this permission is, at least on papers, is a criminal offense, though no one is booked, in criminal cases in India till thus far in the last 75 years. Third is, general for every sector is explore alternatives, which we all the panelists have discussed this: mutual separation agreements, voluntary separation schemes, redeployment, obviously in a very fair and just manner, or put people on garden leave. So the consensual route is almost always more efficient than the statutory route. Fourth is engage early, as I cited earlier in the first slide, that TCS and Samsung showed the cost of not engaging with the employees, unions, or authorities. This is far more greater than the cost of engaging. And the last is never underestimate the human impact. The employees who stay are watching how the employees who leave are treated. So that is the real measure for an employer's credibility in the eyes of the employees. So this is from my end, Celie.
Thank you very much, Gagan. So I think to the question of what can possibly go wrong, TP and Gagan, I think we are all in consensus that actually a lot can go wrong. But hopefully, from our discussion today, the audience will have a rough idea of the best practices and how to mitigate and minimize the risks that the businesses face. I think we have come to the conclusion of our session today, and we would like to open up the Q&A session.
Thank you very much, Sue, and thank you, TP and Gagan, for your insights. We will indeed now move to the Q&A session to answer some questions received. The first one for you, Sue, from Malaysia, about Malaysia. Earlier, you mentioned that your communication is critical. Can you briefly explain some do's and don'ts during the meeting to communicate the retrenchment decision to the employee?
So I think in respect of communication to the employee, again, I think as TP mentioned earlier, I echo what TP has said, there is no one size fits all. But the general rule is also, as what Gagan had said earlier, early consultation is always good. This is a very big decision that's being informed to the employee. Advance notice, it's always, I think, appreciated by the employee. Of course, balancing that against risk of sabotage and other factors that the businesses may consider. In terms of communication, it depends on whether you're communicating to a big group of employees or a small group. If it's a big group of employees, businesses may wish to consider whether a town hall setting may be suitable for the communication. If it's just communication to one employee, and for example, if it is a very senior employee, there are some very I think it's very important for the business to consider as well, even the setting of that meeting. Whether it would be appropriate to convey that information over a virtual meeting, or whether it is best to deliver that information face to face. In terms of the location of the meeting room as well, you may want to choose a location that is more private and not, right in the middle of the office where, it is open for all colleagues to see. In terms of the do's and don'ts as well during the meeting, I think it is very important to explain the reason for the retrenchment. It is very important. I think the human element, as Gagan mentioned, is very important, to be empathetic and to listen to the concerns raised by the employee and to treat the employee with dignity. I would say don't call security to stand at the door, waiting to escort the employee out with their box, right after the meeting. That is, to me, I think a big don't. Maybe we have to think about other sensitivities as well, but I think these are just some of the do's and don'ts that I can think of offhand.
Thank you very much, Sue. We will now move. We are receiving so many questions. We will try to answer as many as possible. A second question for Gagan about India. For India, can you please provide more details on how the full and final settlement process works, including the typical steps and timeline?
Thank you for the question. The full and final settlement is a process by which the employer settles all outstanding dues to the employee at the time of separation. Let me walk you through the typical steps and timelines. The first is that the full and final settlement typically include the following components, which is the salary for the days worked in the last month, notice pay or recovery of notice period, shortfall as the case may be, retrenchment compensation at 15 days average wage per completed years of service. This component is applicable in case you have identified the retrenched employee to be a workman. Leave encashment is another component for any accrued and unused leave. And a gratuity component if the employee has completed 5 years of continuous service, and any pro rata bonus that may be due, and the employer's contribution to the reskilling fund under the Industrial Relations Code. Now, this particular, the last component is something which is yet to come into force, as the Industrial Relations Code have been made effective very recently. So the last component is something which is the futuristic approach which the employers need to keep in mind. Regarding timelines, the Payment of Wages Act, now the Code on Wages, requires that all dues should be settled within 2 working days from the last working day. Now, the gratuity also must be paid within 30 days of it becoming payable under the law. So in practice, the full and final settlement, most employers, they try to process the entire F&F as per their payroll cycle, and this mismatches with the stringent 2-day requirement for wages and retrenchment compensation. So the payments should be planned accordingly. And if it is not possible for the employer to, pay the amount within 2 working days, then consent should be taken from the retrenched employee that this will be paid according to the payroll cycle. So this is and the typical process is on the last working day, the employee received the separation letter and the full and final settlement detailing all the components as a form of, as an annexure, and the employer processes the payment, ensuring all the statutory deductions such as the tax, provident fund, professional tax, they are accounted for, and the employee signs the mutual separation and general release agreement if this has been done, and the employer then issues the experience certificate and the relieving letter. So this is what the entire full and final settlement looks like.
Thank you very much, Gagan. We have a question for Singapore TP. In the termination documentation, is there any difference between using the terms retrenchment and redundancy? Could the terminology affect the employee when filing the MOM notification?
Thanks, Alessia. I will keep my answer short because I see many other questions. I'll answer this in one other Singapore question that I saw. To answer that question, there's no difference in terms of the terms retrenchment and redundancy can be used interchangeably in Singapore. I know it means different things in other jurisdictions, but in Singapore, it's used interchangeably. A retrenchment or redundancy is a definition where it's a loss of employment arising from a reorganization of the business or when there's no intention to replace the particular role. So it doesn't affect you in terms of your notification to MOM when you use the word redundancy or you use the word retrenchment. The second question I saw was in relation to what are the sort of advisory norms in terms of the payments per year of service. So it's very quickly, is this half a month's pay to 1 month's pay per year of service. That's what the MOM puts in the tripartite advisory. They don't say anything more. It's delivery cap vague, because they don't want to constrain what employers can pay. But if you ask me, in my experience, there's also a customer, I would say, a norm where the absolute cap you can put on the number of years of service, they generally expect it to be no less than 25 weeks. That's what the position the unions are taking. 25 months, sorry. The position the unions are taking.
Thank you very much. A question about Malaysia. For Malaysia, when processing a termination, could you please confirm the name of the form that needs to be completed, where it can be addressed, and where it should be submitted?
This is the Borang PK, or the PK form, alphabet P and alphabet K. It is available on the Labour Department's website, and it can be sent to the Labour Department. It can be submitted to the Labour Department.
Thank you very much. We have another question that maybe we have still a bit of time to reply. Are the generally recognized principle identifying if an employee is a worker for India or cover the employee Malaysia, or is it to be decided on a case-to-case basis?
I think very briefly for Malaysia, the covered employee is actually an employee who earns 4,000 ringgit monthly salary and below. Or regardless of the quantum of monthly salary earned, they perform certain types of work, which would be the manual work, supervising manual work, drivers, that type of roles.
Thank you very much. And we have just a couple of minutes to reply to the last one, also for you, Sue. Earlier, you mentioned that employer must have strong justification to depart from LIFO principle. What are some strong justification that Malaysian courts have upheld? For instance, in the Eurasia case, is there any way that the court may have upheld the company's best fit policy?
I think generally for the justification to depart from the LIFO principle, in Malaysia, the courts look at a variety of factors, and the factors that they typically consider would be performance, skill, experience, disciplinary record, even nationality. So there are various factors that the court may look at in total to consider whether it justifies departure from the LIFO principle. So hence, what we normally advise our clients to do is to prepare some sort of point-based system where they can then do a points assessment on all these factors to justify to the court that they are departing from the LIFO principle for this purpose. As to what went wrong in the Air Asia case, I think they only relied on disciplinary, even though they couched it as he was not the right fit because of his performance in 2019. If you look at the facts of the case, what had happened was his performance was marked down severely in 2019 because of a disciplinary conduct. Hence, at the end of the day, he was not the best fit because of that disciplinary conduct that happened. Hence, I think just having one factor alone, that may not be sufficient to justify that departure from the LIFO principle.
Thank you very much. Very clear. Unfortunately, we are running out of time, so we don't have the time to take all of your all of the remaining questions right now. For any further question that you may have, our panelists will remain available via email. You will find here their contact details. As our panelists, and we have mentioned in the very beginning, this is the second of a 3-webinar series on restructuring in the APAC region. The first one was held last week, and recording and slides are available on our website. As also mentioned in the very beginning, the slides and the recording of this one will be also available in the coming days on our website. The third and last one is scheduled for next Tuesday, featuring lawyers from South Korea, China, Hong Kong, and Japan. The registration is still open, and the link is available on our page, events and webinar. Feel free to still register for it. I would also like to bring your attention to our new AI-based platform, Delphius, answering in a quick and concise way to queries on employment law. If you will be interested in receiving a demo and joining our 30-day trial period, please do not hesitate to scan this QR code that you have on this slide to book a demo with us. Finally, I would like to thank everyone for attending this webinar, and a huge thank you to our panelists for their very interesting insights today. With that, the webinar will now be ending. Thank you and have a great rest of the day.
Thank you.
Thank you, everyone.
Thank you, everyone.